and welcome to our program. I'm Rachel Pierce, and I'm joined today by Alan Dorhofer, my coworker. And today's broadcast is the second in a series of installments that we're doing interactively with the Federal Judicial Center on advanced guideline issues. Today's topic is going to be centering on 1B1.3, relevant conduct. As we go through today's broadcast today, our goal is to provide you with a better understanding of relevant conduct, not only what it is, but how it works and how it's going to aid the courts in determining what sort of things the defendant is going to be held accountable for. Now, we're going to be doing that today through discussions and by also looking at case fact patterns from actual calls that we've gotten and different cases that we've seen throughout the years to help illustrate the pertinent application of relevant conduct in the analysis that needs to be done. Before we get started with that, however, Alan, why don't you remind our viewers of some of the housekeeping items that they're going to need to be aware of today?
Sure, Rachel. The first thing that I think you may want to look at is at the bottom of the screen, we're going to have a website that you can find some of the participatory materials that we're going to be focusing on today, such as the slides and some other information. Also, during the broadcast, you will be seeing a fax number coming across the screen at various times, as you can see on the screen right now. Please, and we encourage you to fax in your questions. We're going to be talking about both advanced issues, and for some people this may be in some ways a refresher course, and for others it's going to be one that relevant conduct might be the first time that they're actually hearing the term, so please fax us those questions. Also, we also have a helpline at the Sentencing Commission that we answer questions about relevant conduct or any other questions that we have, and feel free, we're going to put up that number now and also throughout the broadcast as well to call in with questions. And as Rachel mentioned, we will be talking about fact patterns because the best way to learn relevant conduct is actually through case examples and also real-life situations that have developed. The guidelines themselves have a lot of examples at 1B1.3, which we're going to focus on as well. And once again, please fax us with those questions because we'd like to get to as many questions as possible during this broadcast.
Thank you, Alan. Let's get started with sort of a general discussion or an overview, if you will, of relevant conduct. And let me just take a minute here to recognize that we are aware that the audience is made up of members that have varying knowledges of relevant conduct. Some of you may be very experienced with the guidelines, others of you may not. As we go through this discussion, as I said, we'll start off with a general discussion, sort of a brief overview, and then we will move on to some more complex facets of relevant conduct as we near the end of the broadcast today. If for some reason you get lost and you need further clarification on some of the more basic elements, as Alan said, please call us on our helpline. If you feel this program is too basic for you and you have some other relevant conduct issues that are more complex that you would like to discuss, again, please call us at any point on our helpline. And again, that number is 202-502-4545. Having said that, let's go ahead and jump in with a discussion of relevant conduct. Many of you who have heard us train over the years might have heard us refer to relevant conduct as the cornerstone or the gatekeeper of guideline application. And that is because relevant conduct sets the limits of information that is to be used at sentencing. Generally, all information can be looked at as far as sentencing. As far as the court is concerned, the court can look at all information, and this is set out at the statute at 18 U.S.C. section 3661. We've memorialized that section of the statute at our guideline at 1B1.4. And it's important to remember that while all information can be considered, there are some exceptions to that, and the statute does note those. Things such as the age of the defendant, the race of the defendant, the religion of the defendant. But unless there is a specific statutory prohibition about what the court can look at, the court can generally look at all information for sentencing. There are a couple of cases, however, the Supreme Court cases, the Whitty and the Watts case, that also discuss the breadth of conduct that the court can look at when determining what is relevant conduct. Another important fact to remember is that sentencing accountability is not always the same as criminal liability. And we will talk about this frequently as we discuss relevant conduct today. So having said that relevant conduct sets the limits of guideline application, let's talk a little bit more about exactly how it does that. How is relevant conduct structured before we get into the specific analysis of determining which acts are and are not going to be included in our determination of relevant conduct. Alan, why don't you get us started on that?
Sure, Rachel. And the first thing that the court is going to have to look at is to try to make a determination of which acts committed either by the defendant or some other co-conspirators potentially are relevant to this fact situation or to the actual case that's in front of the court. What 1B1.3 is divided into two subsections, 1B1.3A and 1B1.3B. We're going to focus mostly on 1B1.3A today, and what A focuses on, it establishes what is relevant for Chapter 2 and Chapter 3. You're going to be looking to the base offense levels at Chapter 2, the specific offense characteristics at Chapter 2, any cross-references at some of the guidelines, and also the Chapter 3 adjustments are going to be what's focused on 1B1.3A. Subsection B provides that the appropriate analysis for the determination of relevant information for Chapter 4 and Chapter 5. And we're going to save that for another day. We're going to focus mostly on 1B1.3A1 and A2 today. When we talk about relevant conduct, it's really important to look to not only the guideline itself, but the application notes. Throughout the broadcast, we are going to be referring, Rachel and I, to certain application notes. And that's where you'll see a lot of the determinations of relevant conduct will come from examples that you will see in the actual application notes. What 1B1.3A1 and A2 look to is you're looking to the analysis to establish the relevant acts committed by either a defendant or potentially some co-defendants. 1B1.3A3 focuses on the harms for those acts established in A1 and A2, and we're going to focus on that a little bit later as well. And then at 1B1.3A4, A4 is going to address any information, any additional or any other information specified for application in a particular guideline. And 1B1.3A4 is something that we're also going to talk about a little bit later. It's not a provision that is used all that often, but there are specific times within the guideline manual where 1B1.3A4 comes into play.
Thank you, Alan. As Alan said, we are going to focus the majority of our broadcast today on what relevant conduct normally focuses on, which is basically subsections A1 and A2. We are going to touch on A3 and A4 briefly, but those are the sections that are not as frequently used in the discussion of relevant conduct. So having said that, let's go ahead and just dive in and get started talking about the analysis that occurs when you're determining what your relevant conduct is. There are two main questions that need to be answered when discussing the issue of relevant conduct. The first is the who. The second is the when. Specifically, we'll start off here by looking at subsection A1A, which is acts committed by the defendant. So we're looking at what sort of acts did the defendant commit, aid, abet, counsel, command, induce, procure, or willfully cause. And when did those acts occur? Everything is centered around the offense of conviction. Did that act occur either during the offense of conviction, in preparation for that offense of conviction, or in order to avoid detection or responsibility for that offense of conviction? Now, a lot of times when you're making a determination about an act that the defendant committed either during the offense of conviction, in preparation for that offense, or in order to avoid detection or responsibility for that offense of conviction, it can be a very straightforward analysis. For example, if you have a defendant who has committed a bank robbery, let's say this defendant has walked into a bank armed. When you're doing your guideline calculations for that defendant and you're at the robbery guideline at 2B3.1, there is a specific offense characteristic for possession of a weapon. And so when you're doing the relevant conduct analysis to determine if you're going to give that specific offense characteristic, well, you ask yourself, is this an act committed by the defendant? Yes, the defendant possessed a weapon. Did the act occur during the offense of conviction? Well, given the facts that I just spoke about, the defendant absolutely possessed a weapon during the course of the robbery. So again, that's a straightforward analysis. It makes sense. It's easy to understand. However, sometimes this concept of what is during the offense of conviction can be a little bit more complex and a little bit more difficult to determine. Alan, why don't you tell us a little bit about some of the things that can happen when determining whether or not an act occurred during the offense of conviction?
Sure, Rachel. And I think one area that sometimes rises to a level of difficulty for some people is when you're dealing with conspiracies. And that's, I think, where the difficult questions sometimes come in is what is an act during that offense of conviction? There are basically two things that we're looking for when we're looking to the during aspect. As you can see, we're going to be focusing a lot on the acts of the defendant and the certain acts of others. But right now, we're just going to focus on the during aspect of it, during the offense of conviction. During the time, the first thing that we want to look to is obviously the timing of that offense of conviction. However, it cannot just be that the act occurred during the offense of the conviction just on the timing. It must be more than contemporaneous. Just because something happened during a specific time frame that the offense of conviction site doesn't mean that we're automatically going to count that as relevant conduct. The second thing we're going to look for is, besides the contemporaneous aspect, is we are going to look to whether that offense was in furtherance of that offense of conviction. And there are two good places to look for what a description of in furtherance of the offense of conviction. Number one, Amendment 3 and Amendment 439 of Appendix C. For those that might be unfamiliar with Appendix C is where all of the reasons for the amendments that the Commission makes changes to the guidelines. And Amendment 3 and Amendment 439 give a good explanation of really what this in furtherance means. However, just by explaining it that way, I think leaves out the way that it actually operates unless we look to a couple of examples. So why don't we look to a couple of examples to see exactly how this operates. First fact pattern. Conspiracy to distribute meth from January 1st, 1996 to December 31st, 2006. On November 21st, 2002, the defendant was in possession of 3 firearms, during which time the defendant was in the company of 4 others also involved in the conspiracy, as well as a scale and a police scanner. Well, the first thing that we want to look to, Rachel, is we want to look to see, well, did this occur during the offense of conviction? And when we look to during, was it contemporaneous? And the answer is yes. That action of possessing the weapons in November was within that 10-year time frame between 1996 and 2006. However, once again, we must go beyond just the more than contemporaneous and to look to whether it was occurring in furtherance. And with the facts of the police scale and the scanner, I think the court is most likely going to find that this act of possessing that weapons was in connection with and during the time of the offense of conviction, that 10-year gap, and therefore at the 2D1.1 guideline, which is your drug trafficking guideline, there is a 2-level increase if the offense involved the possession of a dangerous weapon. Possessing that weapon in furtherance during that time frame will lead the court to give that 2-level increase. So that would be an example of where in furtherance is really what's driving the 2-level increase. Mm-hmm. However, as with all relevant conduct questions, relevant conduct is very factual driven. The facts of each case may be so different, or they may be just slight differences that the court must make individualized findings, as we'll see a little bit later. And what I want to do now is talk about another example to show the same point, but just how the analysis does differ in some ways. Fact pattern number 1 variation is you look into a conspiracy to distribute methamphetamine from January 1st to 1996. January 1st, 1996 to December 31st, 2006. On October 21st, 2002, the defendant, while going on a hunting trip, possessed 2 hunting rifles in his truck while on the hunting trip. Well, here, the court has to make a determination of whether or not this possession of the weapon was during the offense of conviction and whether it was in furtherance. We have the same time frame, the 10-year time frame that we had in Variation 1, but here the act itself is obviously within that time frame, but the act itself doesn't appear to be in furtherance. The fact that the individual had the weapon on a hunting trip doesn't seem to relate to any of the drug trafficking that the defendant had done during that 10-year period. And if there's no other evidence before the court to show that the defendant carried a weapon or that maybe a co-defendant carried a weapon, here this possession of those firearms while on the hunting trip would not be in furtherance of the offense, and therefore would not be considered relevant conduct, and that 2-level increase that I talked about earlier at 2D1.1B1 would not apply. And this just illustrates how at 2D1.1, while we have a broad definition of what it means to possess the weapon, there are going to be times where just because defendants possess weapons doesn't mean that that enhancement is going to apply. And remember, the act must be in furtherance. That's really important to realize when you're looking to relevant conduct.
Thank you, Alan. As I said, it can be very straightforward, but then you can have fact-specific things that make it a little bit more complex. Speaking of a little bit more complex, let's move on to another part of an analysis of relevant conduct, and that's this A1B aspect of analysis. The first thing you'll notice is that the when component stays the same. We're still evaluating acts within the frame of the offense of conviction. Did they occur during that offense of conviction, in preparation for that offense of conviction, or in order to avoid detection or responsibility for that offense of conviction? But the difference you see here is the who. Who are we looking at? At this point, we're no longer looking at acts of the defendant. We're actually looking at certain acts of others. But in order for our defendant to be held accountable for certain acts of others, there's actually a 3-part analysis that has to be completed by the court. And as you can see here, there are 3 separate determinations that need to be made to determine if certain acts of others can be considered within a single defendant's relevant conduct. The first determination that has to be made is that the court has to determine what the scope of the defendant's jointly undertaking criminal activity is. Secondly, after determining that scope of the jointly undertaken criminal activity, the court has to determine if those acts of others were in furtherance of that jointly undertaken criminal activity. And finally, are those acts reasonably foreseeable in connection with the defendant's undertaking into the jointly undertaken criminal activity? So let's start by looking at each one of these individually. First, by determining the scope. And 1B1.3 Application Note 2 gives the court more guidance in how to make a determination of what the scope of the undertaking is. And the first thing you'll see is that it has to be an individualized determination. And that individualized determination is going to be based on each defendant's undertaking. In other words, the court has to look at each individual defendant and make a decision as to what his or her undertaking is with others in the course of a jointly undertaken criminal activity. Now, this can be established by explicit agreements or implicit agreements inferred from the facts or the conduct of the defendant and or others. It's also very important to remember here that the scope of the criminal activity jointly undertaken by a defendant is not necessarily the same as the scope of the entire conspiracy. And what we mean by this is that criminal liability, in essence, is not always the same as sentencing accountability. For example, a defendant can be criminally liable for, let's say, a drug conspiracy that may span over the course of 10 years. But as far as what the defendant is going to be accountable for under relevant conduct for sentencing purposes, that may be a little bit more narrow, depending on what exactly the defendant did, what exactly the scope of the undertaking is for jointly undertaken criminal activity. So you have to keep in mind that sentencing accountability is not always the same as criminal liability. Moving on, the second thing that needs to be determined after the court determines the scope of the defendant's jointly undertaken criminal activity is acts of others, are they in furtherance of what the defendant agreed to do with the other defendants in the case? And finally, are those acts reasonably foreseeable? And remember, we're talking about reasonably foreseeable to a reasonable person here, not just reasonably foreseeable to the defendant, because it might not be reasonably foreseeable to the defendant. In other words, I just want to give a quick example right here. If you have, let's say we have two defendants who are going to rob a bank, and they both walk into the bank together, and only one of them, however, is armed. And let's say we're writing the pre-sentence report on the defendant who walks into the bank without the weapon. Okay, we're doing our guideline calculations at the robbery guideline at 2B3.1, and as we had discussed in a previous example, there is a specific offense characteristic for possession of a weapon. Well, our defendant did not possess the weapon. So we're moving on to look at certain acts of others. Is our defendant still going to get an increase because the co-defendant did walk into the bank? Well, applying the three-part analysis, the first step the court has to make is, what is the scope of the agreement? I think it's pretty clear from the facts that we've discussed that the two defendants agreed to rob the bank together. The next question that needs to be answered is the act of the co-defendant carrying the weapon in furtherance of the agreement? Well, I think it's reasonable that people would argue that the act of carrying a weapon through the course of a violent offense such as robbery would be in furtherance of the general agreement, which was to rob the bank. And lastly, is it reasonably foreseeable that the act of carrying a weapon would be in furtherance of the jointly undertaken criminal activity, in this case, the robbery? And again, a reasonable person, I believe, would argue that it's reasonably foreseeable through the course of a violent offense such as robbery that a weapon would be not only possessed but even possibly used. So again, we've completed our three-part analysis, and we've occurred that this occurred during the offense of conviction, and so it's going to be included as relevant conduct. I want to make another point about this concept of what is reasonably foreseeable. It's very important to remember that it's only one part of the three-step analysis, and it does not impact conduct that the defendant is only responsible for. You're only talking about the concept of what is reasonably foreseeable when you're talking about the conduct of others. And the guidelines actually give us a bright line rule at 1B1.3 Application Note 2 that says relevant conduct does not include the conduct of members of a conspiracy prior to the defendant joining the conspiracy, even if the defendant knows of that conduct. So going back to this concept of what is reasonably foreseeable, again, if you're making a determination at A1A, which is an act committed by the defendant, you're not discussing the concept of what is reasonably foreseeable, because that only enters the equation when you're talking about the three-part analysis and possibly holding your defendant accountable for certain acts of others. along with that, mere knowledge of other activity is not enough. It may be reasonably foreseeable within the scope of a drug conspiracy that others would be dealing drugs. But that mere knowledge and the concept that something is reasonably foreseeable is not enough, because the first thing you have to determine is what is the scope of the agreement. If there is no scope of a jointly undertaken criminal activity, then you don't even get to the second step of what is, or the third step, excuse me, with what is reasonably foreseeable. So that's an important thing to remember. And again, since fact patterns are such a good way to illustrate the points that we're trying to teach, let's take a look at another fact pattern. In this case, we have a drug conspiracy that's charged from January 1st, 2002 to December 31st, 2006. Our particular defendant, however, entered the conspiracy January 14th, 2006. The defendant, our particular defendant, through the course of his involvement in the conspiracy, distributed a kilo of marijuana for 50 weeks for a total of 50 kilos of marijuana. These particular facts indicate that the defendant also worked with co-defendants who also distributed 50 kilos over a period of 50 weeks. So what we have here is we have defendants who are involved in a drug conspiracy. And let's say, for purposes of discussion, that the facts of this case indicate that they were all working in concert with each other, in that even though they might have had different areas in which they sold the drugs, they would help each other if one of them was running low or was running out of drugs or that type of thing. They were working in concert with one another. So clearly, when we're doing the pre-sentence report for our one defendant, we can do the analysis of acts committed by the defendant during the offense of conviction. The 50 kilograms that our defendant distributed during the course of that conspiracy, he is going to be held accountable for. The question then becomes, well, what about the other 50 kilos that each one of those other co-defendants distributed? Well, since we're looking at certain acts of others, we're going to do the three-part analysis and look to each step. First being, what is the scope of the agreement? Given the facts of this case, the defendants all agreed to distribute drugs together and to help each other out should the need arise. Secondly, are the acts of others in furtherance of the jointly undertaken criminal activity? Clearly, when all of the players are distributing drugs together and helping each other, that's in furtherance of the larger goal, which is the drug distribution conspiracy. And is it reasonably foreseeable when you're in concert with others distributing drugs that they're going to be distributing drugs to further that conspiracy? And I think the answer is pretty clear that that's yes. All again occurring during the offense of conviction, which is the dates of the conspiracy. But there again, because relevant conduct is so fact-specific, sometimes that analysis can change. Alan, why don't you walk us through an example where it would change the analysis?
Sure, Rachel. Let's look at another example here, and this comes from another real case that occurred in the federal system. There was a drug conspiracy charge from January 1st, 2004 to December 31st, 2004. Two defendants each carried 1 kilo of cocaine across the U.S. border on 5 separate occasions. Each defendant picked up the drugs from the same supplier, but each crossed the border on separate days. First reaction might be, well, here we have what, as Rachel just talked about a little earlier, a drug conspiracy. Are we going to hold the defendant accountable not only for what he brought across the border, but also what some people may say his co-defendant or another backpacker did? But here, I think when you go once again to that three-part analysis, you're going to look first to the first question is, what is the scope of the defendant's undertaking? In the scope of the defendant's undertaking here would be defendant A, the first backpacker, decided that he was going to, on 5 occasions, go across the border with 1 kilo of cocaine going to a supplier. He wasn't working in concert with anybody. There was no planning with the other backpacker. And even though they might have shared the same supplier, the scope of the defendant's undertaking seems to be, at that particular point, is just limited to his actual role in those 5 occasions that he himself crossed the border. Now, if they had maybe worked together and gone across the border at the same time, but here, going across the border on separate occasions, they didn't plan the actions together. Just because they share the same supplier does not mean that we're going to hold the defendant accountable for everything within that conspiracy. Now, some may argue, well, isn't it reasonably foreseeable that if one backpacker is going across and there may be some other folks that are involved in this conspiracy, isn't it reasonably foreseeable that other people would be going across the border? But we don't get to the reasonably foreseeable approach yet, or the criteria, unless you look to the scope of the defendant's undertaking first. And that's what we're trying to emphasize here, is that the first thing you have to do is look to the scope of the undertaking. And in looking at a lot of appellate cases, they look closely at not only the scope of the undertaking, but that each case in which there are multi-defendants, there must be an individualized finding. And Rachel mentioned that a little bit earlier, and that is an extremely important point, as you can see by this fact pattern. Each individual defendant in the case, each individual co-conspirator, the court needs to make a finding on their own scope of the undertaking, then look to the acts of the defendant and others, and then also look to the reasonably foreseeable. But you don't get to reasonable foreseeability unless you make the determination that it was within the scope of the defendant's undertaking. So you see this come up in a lot of situations when you have backpackers or you have drug conspiracies or fraud cases. We've now looked a lot at 1B1.3A1. We're going to move a little bit now to a little different direction to focus on 1B1.3A2. And what 1B1.3A2 looks to is it's going to expand in some situations the offense of conviction. The offense of conviction, we talked about anything that occurred during the offense of conviction, in preparation for that offense of conviction, or to avoid detection for that offense of conviction. However, relevant conduct will be different for certain type of offenses. And there's a term of art that has come about called expanded relevant conduct. And while you may not find that term in the actual guideline manual, all circuits across the country have used this term expanded relevant conduct. When the Sentencing Commission, when the trainers and the lawyers go across the country and the commissioners, we hear everyone asking questions about expanded relevant conduct. And let me try to explain what expanded relevant conduct means. The first thing is to make a determination if the offense of conviction or the offense is listed at 3D1.2D. Now, while 3D1.2D is a guideline that is concerned with multiple counts of conviction, 3D1.2D also focuses on relevant conduct at 1B1.3. If an offense is listed at 3D1.2D, and it's one of the type that can be grouped at this guideline, then we are going to be looking to see that the offense of conviction time frame can be expanded. Let me give some examples of what these type of offenses look like. Drug trafficking, fraud, theft, and embezzlement, money laundering, firearms. These are type of offenses in which things can be aggregated together. Normally, things that can be aggregated together, if an individual distributes drugs, you can add up the amount of drugs. If the individual has committed a fraud, you can add up the amount of loss that the individual has caused on a number of occasions. And what we're doing here by looking at this list is these type of offenses allow the court to expand the time frame of the when component that Rachel talked about earlier. You have the who component, then you have the when. This expands this list of cases. And you're going to be looking at the majority of cases within the federal system, probably about 60% on an approximation, will have this expanded relevant conduct potentially applying. Now, just because it's listed at 3D1.2D doesn't mean that all conduct that the defendant and his co-defendants engaged in will automatically be considered to be relevant conduct. Now, there's also a list of offenses which are specifically excluded from having expanded relevant conduct or having the when component to be expanded. These examples include robbery, murder, kidnapping, assault, rape cases. Cases normally involving, as a general rule, one way to try to remember this, Rachel, is physical harm cases are those types that normally do not allow for this expansion of the when component. However, once you have made that determination that it is on the list of offenses, then you have to make a determination if it's the same course of conduct, common scheme, or plan. But even before we get to that, one thing to keep in mind is you have to make sure it's listed at 3D1.2D, then see if it's part of the same course of conduct, common scheme, or plan. But one of the things that you have to look to is, don't forget, you have to make a determination. We're still looking at everything under 1B1.3A1A, 1B1.3A1B, and your offense of conviction. Because sometimes people like to just jump to, well, is it part of 1B1.3A2? When oftentimes those acts often may fall under 1B1.3A1A, A1B. It's very important to realize to go through the analysis correctly. And once you have made that determination that it's beyond 1B1.3A1A and A1B, to look to the same course of conduct, common scheme, or plan, the guidelines give some examples at application note 9A of what we mean by common scheme or plan, and then also same course of conduct with that at application note 9B. For common scheme or plan, offenses must be connected to each other by at least one common factor, such as common victims, common accomplices, common purpose, or similar modus operandi. If you have one of those, most likely going to be a common scheme or plan if it has one of those offenses listed at 3D 1.2D. However, even if you don't find common scheme or plan, you might look to same course of conduct, and that's listed, as I mentioned earlier, at application note 9B at 1B 1.3. Also, Appendix C at Amendment 503 also gives a good illustration of what same course of conduct means. You're looking to similarity of the offense, and we're going to go over some examples of this shortly. Regularity, the repetitions. Are these individuals or is this defendant doing this on a number of occasions? And the temporal proximity. How often are these offenses occurring in a time frame? This U.S. versus Hodge case that you saw at the screen gives a good example of when one of these factors, such as potentially maybe the temporal proximity, may not be strong. If one of the other factors is strong, such as regularity or the similarity, that may compensate for the fact that the temporal component may not be as strong as the other factors. And as I said, I think the best way to illustrate what common scheme or plan looks like and same course of conduct is through an example. So why don't we look at an example? Look at fact pattern number 3. Here you have a defendant convicted of tax evasion for failing to pay taxes in 2004. Facts also illustrate the defendant also did not pay taxes in 2003, 2002, and 2001. The question for the court is the tax loss from 2001, 2002, and 2003 relevant conduct? First thing we want to look to is, what's the offense of conviction? The defendant was convicted of failing to pay taxes in 2004. However, we are looking at this offense and we are looking at a time frame in tax evasion. Well, tax evasion is one of those guidelines, Rachel, that is listed at 3D 1.2D. And therefore, since it's listed at 3D 1.2D, the court can go beyond that offense of conviction, that one-year time frame, to look to other conduct that the defendant has committed. In looking to that other conduct, first we'll focus on common scheme or plan. Remember, we talked about common purpose, common victims. Well, here you have a common victim. The government was not being paid taxes for 2004 and the 3 preceding years. You also have individuals looking for that common scheme, similar modus operandi, where you have an individual who's not paying taxes, not just 1 year, but 3 years preceding to that. So you're probably going to have a pretty strong case for the court to find that 2003, 2002, and 2001 conduct can be brought into the equation. Now, even if the court didn't find by the common scheme or plan, remember we have same course of conduct. Same course of conduct, we were looking at similarity, regularity, and temporal proximity. Well, one argument might be raised by the defendant, well, these offenses, the temporal proximity, they're separated by a year. That's a pretty long time. Well, remember, with tax evasion, I think the first thing that might be argued is that these offenses only occur once a year. You don't pay your taxes on more than one time a year. At least most people don't. And then you are looking at also the regularity and also the similarity. The similarity, this is now 4 years in a row the defendant has not paid taxes. So I think the court is probably going to make a finding in this particular case, and in the actual real case they did, saying that this conduct from the other 3 years, to 2003, 2002, 2001, based on the similarity and the regularity, that tax loss can be used at the tax guideline, so the loss from those 3 years would be brought into the equation for the offense of conviction. And that just illustrates how, with the tax loss case, or with fraud or with drugs, those offenses listed at 3D 1.2D, other conduct can be brought into the equation. But you have to also focus, do not forget to focus on 1B 1.3A1 and 1B 1.3A1A and A1B, and then you get to 1B 1.3A2.
And I think that's a great point, Alan, that you make. And we focused on the analysis that has to be done. And Alan's absolutely right. You have to start out with, is this an act committed by the defendant? Did it occur during the offense of conviction, in preparation for that offense, or in order to avoid detection or responsibility? And in this case, we do have the defendant convicted of at least 1 year where he failed to file taxes. So clearly, that occurred during the offense of conviction. But certain types of offenses, as Alan's told us about, could expand the kind of conduct that we're looking at. And a tax offense is one of those offenses. And as Alan mentioned, a large number of the cases that you're going to see are going to fall within expanded relevant conduct, and you can look to the same course of conduct, common scheme, or plan. So it is important, hopefully we've illustrated, to go through each and every step of the analysis to determine what exactly you're going to be including, because as you can see, it can narrow depending on the facts, or it can expand depending on the facts. And again, we started off by saying that the majority of the focus for your relevant conduct analysis is in sections A1 and A2. But sometimes we do reference A3 and A4, and we're going to go ahead and talk a little bit about that now. Starting by looking at section A3 of relevant conduct. And we reference you here to application note 4. What we're talking about here in section 3 of A3 of relevant conduct is really kind of an intuitive concept, in that it makes the harms from the acts of the defendant or acts of others that our defendant is held accountable for, makes them relevant. Harms such as loss, injury, damage to property that may occur. Again, all within the context of, is it an act committed by the defendant, or is it a certain act of another person that our defendant's going to be held accountable for? In other words, what we mean is this. The concept of loss, for example, is not an act that the defendant commits, okay? Loss is a specific offense characteristic at 2B1.1, the fraud and theft guideline, but loss is the result of an act that the defendant commits. So the defendant is either stealing something or committing some sort of mortgage fraud or bank fraud. The harm that results from that is the loss. So that would be something that would be captured under 1B1.3A3. Similarly, injury is not an act committed by the defendant. If the defendant is assaulting another person, the harm that results from that is the injury. The act is the assault itself. So as you can see, it's somewhat of an intuitive concept, but when you break it down, it does fall under 1B1.3A3. Another example of a harm that results from the offense would be, let's go back to the robbery example. I love to use the robbery example when I'm talking about relevant conduct. But let's say the defendant goes into the bank, robs the bank, and among all the commotion, one of the tellers decides, this is a perfect time for me to slip a couple hundreds or 3 or 4 or 5 or 6, however many they can get away with, into my pocket because nobody's paying attention. Well, arguably, that's clearly a harm that occurs because of the offense. Okay? The bank is out that additional money that the teller decides he or she's going to slip in her pocket during the course of the robbery. However, again, has to be evaluated within the context of A1A and A1B. Is this an act committed by the defendant? Is this a harm that results from an act committed by the defendant? Or is this a harm that results from the act committed by someone else for which our defendant is held accountable for? Well, clearly it's not an act committed by the defendant because the defendant's the one robbing the bank and the teller is the one that works there. And I think that everyone would probably be in agreement that the defendant and the teller are not in a jointly undertaken criminal activity to rob the bank. So while, yes, this is a harm that results from the robbery, it's not going to be included in the relevant conduct analysis because it doesn't meet the definition of an act committed by the defendant or certain act of others that the defendant is going to be held accountable for. Moving on, let's move on now to talk about the A4, which is even more of a complex and somewhat obscure application of relevant conduct, but nonetheless important. Alan, why don't you tell us about that?
Sure, Rachel. And 1B1.3A4 focuses on, as we saw a little bit earlier, any other information specified in the guidelines. So while we've been talking about 1B1.3A1, A2, and A3, what A4 is looking to is any acts beyond the 1B1.3A1, A2, and A3 situation. You're mostly going to be focused on this in the application in Chapters 2 and Chapters 3, and they're going to be limited to discrete guidelines in which the information is specified. Now, they may have some limited impact on Chapter 4 for some guidelines, but in reality, you're really going to be focused on this in Chapter 2. And let me give an example of where this 1.3A4 comes into play. 2G2.2 is the guideline that is associated with the trafficking, receipt, or possession of child pornography under 18 U.S.C. 2252. One of the specific offense characteristics at this guideline is that 2G2.2b5 states that there is a 5-level increase if the defendant engaged in a pattern of activity involving sexual abuse of a minor. Now remember, the person who is being sentenced using this guideline at 2G 2.2, his offense of conviction is trafficking, receipt, or possession of child pornography. It's not the sexual abuse of a minor. Well, this application note, there's an application on Application Note 1 that instructs the court to see when this 2G 2.2 B5 situation applies. If a defendant has sexually abused a minor on more than one occasion, that's when this 5-level increase applies. However, in order for the court to make that finding here, sometimes it may be necessary, and this is what Application Note 1 states, this pattern of activity means any combination, whether or not the abuse or exploitation, and there's three parts, A, occurred during the course of the offense. The key language, as you can see, is whether or not it occurred during the course of the offense. So here, what the Commission is telling the court and telling individuals who are using the guideline system is go beyond your 1B1.3 A1, A2, and A3 analysis. You still have to go there to see if this act and this specific offense characteristic falls within that relevant conduct provisions. But if not, 1B1.3 A4 allows the court to then make a determination that this individual sexually abused a minor and then to give this 5-level increase. And as I mentioned, this is not something you use all that frequently. That's why we're focusing most of our attention on 1B1.3 A1, A2, and A3. But A4 does allow the court to go beyond those three provisions of the relevant conduct to look to see if there's any other information specified in the guidelines. And the background information at 1B1.3 also lists some other examples of where A4 does apply. So if you're running into a situation where you may not be as familiar with 1B1.3 A4, look to the background information at 1B1.3 and it gives some illustrations there. Now, with that, one of the things that we want to cover today is a number of questions that we've received. But before that, we've done a lot of information so far, we've given you a lot of information so far, is we want to give a recap of what we have actually talked about today, because we know with 1B1.3, there's a lot of analysis that is involved in these type of cases. And remember, the first thing we want to look to is the who. There are two main questions you want to ask, who and when. First question is the who. You're looking at 1B1.3 A1A, 1B1.3 A1B. You're looking to acts of the defendant and also potentially certain acts of others. And Rachel talked about that three-part test, scope of the defendant's undertaken, were those acts in furtherance of that, and then was it reasonably foreseeable? And we're looking to, the first thing we want to look to is, did these acts occur during the offense of conviction? Did they occur in preparation for that offense of conviction, during the offense of conviction, and avoiding detection for that offense of conviction? Now remember, when we look to during, it's not just contemporaneous. It must be more than that time frame. It must be an act that's in furtherance. We looked at a couple of examples illustrating that point with the firearm and the possession of firearms in relation to 2D 1.1. Then remember, after you've done this analysis, is there going to be certain offenses, and relevant conduct is not, as one judge said, not created equal, because certain offenses have the application of 1B 1.3 A2. And those are the offenses that are listed at 3D 1.2D, drug trafficking, money laundering. You're looking also at firearms, fraud. And then there are going to be certain offenses that are excluded. And those are your robberies, your physical harm type cases, robberies, murders, rapes, those type of cases excluded. If it is listed, the court then can expand the when component, that offensive conviction, and go beyond the offensive conviction time frame to potentially other conduct. And we looked at that with same course of conduct or common scheme or plan. And then obviously you have the A3 and the A4 that we just talked about. So with that, Rachel, I know we've gotten some questions in.
We have gotten some questions, and you're up first.
Okay.
Okay. This one is from the Eastern District of Louisiana, tax evasion.
Okay.
Defendant charged with tax evasion. If some of the tax loss is outside the statute of limitations for the purposes of prosecution, can we still include that tax loss in the expanded relevant conduct when applying the guideline at 2T 1.1?
And that's a very timely question and a question that we've gotten a lot when we use the example of that tax loss because of the statute of limitations, particularly with tax evasion charges. While the guidelines themselves don't reference a statute of limitation, all the appellate courts that have looked at this issue have all said that yes. Now, while a defendant may not be able to be charged with that other conduct, so if there's some tax evasion charges where the statute of limitations has run out and therefore the defendant can't be charged or the counts have to be dismissed, that conduct, as long as it meets the 1B1.3 analysis, the court can then use that if it, as we said, if it meets 1B1.3A1, if it falls under 1B1.3A2, same course of conduct, common scheme or plan, the court can use that information even with the statute of limitations situation. So,
okay.
Right. I see we have another question here.
We do.
Caller is writing a pre-sentence report on a defendant that committed 7 bank robberies in a 14-day period. The defendant pled guilty to 3 of these robberies. The caller asked how to take into account the other 4 robberies. So it's a helpline call that we received.
Okay. In this case, first of all, we start out with the basic analysis of relevant conduct. What are the acts that the defendant committed, and did those acts occur during the offense of conviction? Well, for the 3 robberies that the defendants actually pled to, we can do this analysis of what sort of acts did the defendant commit during that robbery or in preparation for that offense or in order to avoid detection or responsibility for that offense. So if any loss that occurs because of those bank robberies, if there's any weapon enhancements that might occur or apply, any injury that might have occurred, with respect to those 3 that the defendant pled to, that's the analysis we're going to be doing. It's going to focus on what the defendant did during the offense of conviction in preparation for that offense or in order to avoid detection or responsibility. From the facts that we have here, there's no need to move on to whether or not we can include certain acts of others because it seems that this defendant acted alone. But the next question is, well, can we move on to acts that the defendant committed that are part of the same course of conduct, common scheme, or plan? In other words, can we look at anything that occurred in those other 4 robberies that the defendant did not plead to? Well, as you may recall, Alan gave us a list of offenses for which expanded relevant conduct applies. And at 3D1.2D, the guidelines are very clear about which offenses for which expanded relevant conduct applies and for which offenses it doesn't. And robbery is one of those offenses for which expanded relevant conduct specifically does not apply. So in this case, the court would not be able to factor any behavior loss, harm, any sort of anything that occurred during those other 4 robberies into the guideline application itself. It may be possible that there would be departure considerations or possibly variance situations under 3553A, but for guideline calculation purposes, the court is not going to be able to expand beyond that offense of conviction to same course of conduct, common scheme, or plan.
And that's a very good question, and one that particularly defense attorneys and AUSAs want to know about before you enter into any plea agreements, because oftentimes by entering into certain plea agreements, certain conduct that may not be able to be brought in on the government's behalf, and the same thing where you're looking in some situations where it may be beneficial to the defendant to plead to certain counts that therefore some of those counts of conviction, the conduct that occurred, may not be occurring. That's why it's really important to look to that 3D1.2D list to see which offenses are listed.
Okay. We have one more question here.
Okay.
Actually, we have a couple more, but we'll start with this one. From the Southern District of Illinois, we have a defendant who's convicted of 1 count of obtaining a prescription by fraud. The statute is 21 U.S.C. 843A3. The indictment states that on one date, the defendant obtained a prescription by fraud. However, surprise, surprise, the defendant's been engaging in this type of activity for over 2 years. So can we look at any of that conduct that's occurred in the previous 2 years, or is the court going to be limited to the conduct that occurred on the date in the indictment, which is that one day that the defendant acquired that prescription by fraud?
And that's a real interesting question. I think the first reaction I think most people would have is we're dealing with drug trafficking.
Right.
Well, drug trafficking is listed at 3D1.2D, at least 2D1.1 is. And this is an illustration of where relevant conduct becomes very fact-specific, not only on the actual conduct, but the actual statutes that have been charged. Here, you're looking at 21 U.S.C. 843A3. Well, when you go to Appendix A, where after a defendant has been convicted of a particular statute, Appendix A tells the user of the guideline what guideline to actually go to at Chapter 2. This is a guideline, is not at 2D1.1. This statute references to 2D2.2. 2D2.2, when one looks to 3D1.2D to see if it's on the list of offenses in which expanded relevant conduct would apply, 2D 2.2 is specifically excluded. So therefore, by being specifically excluded, it's in the same categories that we talked, Rachel just mentioned, the robbery fact pattern. This is a type of offense that is specifically excluded from this expanded relevant conduct, so you will not be able to look to those additional conduct from those preceding years under the 1B1.3A2 analysis. But that's why it's so important to look to, don't just assume it's a drug trafficking situation. It's the same thing. Possession of drugs, someone who's convicted of possession of drugs goes to Guideline 2D 2.1, and a Guideline 2D 2.1, that is not listed at 3D 1.2D. That's another situation where you could not use that expanded relevant conduct. So that's an issue.
Thank you for that, Alan.
I see we've got one more question.
Yes, we do.
Here we have a defendant who is a crack dealer who lived with 2 other crack dealers in a house. Defendant sold crack independently from his 2 roommates. Defendant's supplier was not the supplier for his 2 roommates. Defendant has knowledge of the drug dealings of his other 2 roommates. Can the defendant be held accountable for the drugs sold by his 2 roommates? So we're going beyond the defendant's actions here.
Right, right. So we're moving beyond that A1A analysis to the A1B analysis. Are we going to hold our defendant accountable for the other drugs that his roommates basically are distributing? Well, this brings us to the 3-part test that we have to do. And the first part of that test being, what is the scope of the defendant's jointly undertaken criminal activity? Well, I think given the facts in this case, there is no agreement between the roommates to agree to sell anything. They're getting their drugs from different dealers, even though they may live in the same place, they may even hang out together. They're distributing their drugs independently of each other. And so we don't even have to go to steps 2 and 3, which is whether those acts are in furtherance of the conspiracy or reasonably foreseeable. And again, just because the defendants may know that the other ones are distributing crack, that's not really relevant to our analysis here, because we're stopping with the discussion of what is the scope of the undertaking. These facts don't seem to indicate that there's any jointly undertaken criminal activity. So in this particular situation, our defendant's only going to be held accountable for the drugs that he or she distributed.
Great.
Right.
And that just shows the application, the analysis that needs to be done with all 1B1.3 type cases, any type of relevant conduct cases, because I think sometimes people like to just assume when you're dealing particularly with conspiracies, drug trafficking and fraud situations, particularly telemarketing fraud situations, sometimes where people are in the same room calling the same a number of people, you can't just automatically assume that the defendant is going to be held accountable for everything. I think Rachel just illustrated that point once again, and that's a really important point to hammer home, is that in all cases, you must do that individualized findings, because that's where the appellate courts will send the case back if there's not the individualized finding that's there.
That's right. Well, we've covered quite a bit of information today. We've talked a lot about the analysis of relevant conduct, looked at fact patterns, answered some questions. Again, if there's any other questions that you may have, if you need further clarification on anything, please call us at any time on our helpline at 202-502-4545. The next installment of the Advanced Guideline Issues series is going to air in August. If you have any ideas or thoughts on topics that you would like for us to cover, please note that on your evaluation form, as well as any other comments or concerns that you have. And unless, Alan, you want to add anything else to the discussion?
Well, I think Rachel has summed it up great, but there is one thing I just want to add today for those watching at home today. I just want everyone to know that the Supreme Court issued the Rita versus United States case today, in which they held that a court of appeals may apply a presumption of reasonableness to a district court sentence within the guidelines. For those watching at home today, you might want to go and read the copy of that case, and the Supreme Court just issued that case today, so I think it's very timely with the broadcast today.
Thank you very much.
On behalf of both Rachel and I, we'd like to thank everybody for their time, and please feel free to call us anytime on our helpline. Thank you.
Thank you, and have a great day.